Hello and good afternoon. Thank you for joining me for this hopefully brief seminar. I'm Luke Trim and I'm a barrister practicing civil law at Guildford Chambers, and my main specialisation is in property law. Over the last year, I've dealt with a number of cases which have turned upon the interpretation of the right of way, which has served as the inspiration for this seminar. It's often the case that a property dispute between neighbours turns upon disagreement over the scope of what a right of way permits, whether that right is a prescriptive one or express. That disagreement can raise from who precisely can use the way, what vehicle can be used on the way, and what purpose the way can be used for. Such disagreements can often lead to expensive and protracted litigation, often with high risks and relatively binary results. So my intention today, therefore, is to provide a handy primer to assist property practitioners in advising their clients at an early stage on the court's likely approach when assessing the extent of a right of way. Hopefully, this will also be of some assistance for those who are likely to be involved in drafting the terms of an express right of way, whether on a general contractual basis or as part of some kind of settlement agreement. I'll also set out some guidance offered by the authorities on the meaning of many common phrases used in express rights of way, and we'll seek to deal with several common areas where disputes often arise. I'll begin by focusing on expressly granted rights of way, and as ever it's best to start with broad general principles and identify what is likely to be the court's starting point. It is an old lawyer's joke to say that when you're a law student and someone asks you a question, you tend to say, "I don't know." Whereas when you're an experienced lawyer and someone asks you a question, you can instead say with certainty, "It depends." Obviously that's an exaggeration, but it has some applicability here. It is made clear throughout the authorities that this is a very fact-dependent exercise, and no principle will apply absolutely to every single case. Older authorities are therefore helpful and can be influential in other cases, but will not themselves be conclusive. Nevertheless, we can derive soft rules and starting points from the authorities that will assist us in advising clients on the extent of what their right of way grants them. Starting with first principles, unsurprisingly, constructing an instrument conferring a right of way will be performed on the same principles as the construction of any other instrument. As set out in Arnold and Britton, this is an objective exercise, considering what a reasonable person, having all of the background knowledge which would have been available to the parties, would have understood them to be using the language to mean. As McGill and Stewart confirms, the purpose of the grant and the context of the transaction are important to interpreting the extent of an express right of way. In determining what is covered by a right of way, the courts will therefore focus on the wording of the deed, the overall purpose of the clause, and the factual circumstances known to the parties. But notably, they will exclude the parties' subjective intentions at the time that the right of way was agreed. One should also note that the starting assumption is towards a more extensive right. Unless there is something in the words used or the surrounding circumstances that limit the right of way, it will be assumed that it can be used for any purpose for which it can be conveniently enjoyed. The uses a right of way can be put to will not, therefore, be limited to what could be said to be in the minds of the parties at the time that the grant was made. With that starting point in mind, we can move on to look at the examples we have of how the courts tend to interpret specific common phrases that are used to describe rights of way. For all purposes. Obviously, this suggests a broad right without limit and will be regarded as covering any use of the right of way that is not excessive. Further, in some circumstances, it will even allow an owner of the dominant tenement to use that right of way to travel further onto other adjacent land via their property, provided that that use is not excessive. However, if that other land ceases to be part of the dominant tenant's property, such as by sale as a separate plot, then the right of way can no longer be used for that access. The phrase with or without vehicles will normally permit any vehicle that can conveniently use the way, that is to say, fit along the length of the way without any particular difficulty. Generally, there is no distinction made by the courts between cars, lorries, tractors, or any other kind of vehicle. It's also noteworthy that a vehicle is a broad term and will include, for example, horse-drawn carts. Now, the phrase with or without motor vehicles, one might assume that this would exclude the use of horses or horse-drawn vehicles. However, this was held not to be the case in Woodhouse and Kirkland, which included the right to lead or ride horses within that phrase, but did not necessarily include the right to drive cattle. The justification for that conclusion was that the principle that a greater right must include a lesser one. Thus, someone with a vehicular right of access would include a right to ride horses, and presumably a vehicular right of access or even a right to simply use horses would also have the right to walk along the way, even if on foot is not expressly stated in its terms. The inverse of that is perhaps the phrase on foot only. Unsurprisingly, this will usually have the effect of excluding the right to drive any vehicles along the way. However, it will, in appropriate cases, where the width and nature of the way allow it, include the right to wheel a bicycle or carry heavy goods along. This was the case in Clay and Gardner, where the owner of the servient land was required to remove a kissing gate he had installed, as this prevented a user from carrying a bicycle or a dinghy along the way. Now, I should note that, as an aside, while it's not specifically dealt with in the authorities, one can readily assume that this would therefore also include the use of push prams, wheelbarrows, and any other hand-controlled wheeled vehicles, wheeled items, I should say, along a right-of-way, even if it's restricted to be by foot. So what about where the right-of-way is worded to allow travel to a specific location? This was the case in Allen and Gom, where a right was granted for passage through the stable and loft over the same, and a space and opening under the said loft used as a woodhouse. In that case, it was held that this meant that the defendant was confined to the use of the way to the place which should be in the same predicament as it was at the time of making the deed. But notably, the court did not find that the right-of-way depended on the space still being used as a woodhouse. To put that another way, the wording was taken as a means of describing the relevant destination of the way, seemingly regardless of what was later built upon that site or to what use it was later put. Looking at all of these authorities, it's worth noting that, in general, it seems that when dealing with express grants, the courts seek to, where possible, enable a valuable right-of-way to be used for more modern purposes. This remains the case even where that purpose can often never be said to have been in the original party's contemplation at the time that the right was granted. However, where a new use is unduly onerous on the servient tenement, the courts are still able to construe words of limitation, where possible, with the language used. After the wording used in the right, perhaps the most important factor in analysing a right-of-way is the physical characteristics of the way itself, particularly at the time that the right was first granted. The case of Mills and Blackwell, which was quoted with approval more recently in Oliver and Simmons, gives some assistance on what part this plays in the court's assessment. The surrounding circumstances to which the court is entitled to have regard include, but are not limited to, the physical limitation on the exercise of the right-of-way. To put that in more plain English, the physical characteristics of the way are highly relevant, but will not always be determinative. The court will take account of both the words and the physical extent of the way and will weigh them together with any other relevant factors. Doing so, the court should interpret the right-of-way to give effect to the purpose it was designed for and actually used. Though, as we noted earlier, this does not mean that the right will be limited to what was in the minds of the parties at the time that the grant was first given. And finally, it should be noted that where the width of the way is expressly defined in the grant via specific measurement, this will generally be determinative. In those circumstances, it will be difficult for either party to state that the measurements are simply incorrect due to the physical characteristics on the land. If those circumstances do arise, a party wishing to remedy an error in a grant cannot simply seek a declaration that contradicts the wording contained within. Instead, they will need to make a claim to rectify the instrument that granted the right of way in the first place. To illustrate these principles of how physical characteristics affect the way, we have some of the more well-known authorities. In Todrick and Western National Omnibus Co. Limited, the defendant was using the right-of-way to frequently move its multiple buses down a relatively narrow road. There it was determined that this fell outside the scope of the right-of-way. This was because there was insufficient clearance on either side of the buses at the narrowest point. In fact, the clearance was less than 3 inches on either side. That's 7.6 centimetres for any of the younger people listening. It was also considered relevant that there were doubts that the retaining wall next to the way could handle the weight of multiple buses. In Bulstrode and Lambert, a way was granted with or without vehicles over a route which included a gateway partway down its length. The gate had an overhead bar that restricted the size of vehicles that could pass under it to only hand carts. The gate and the bar were both present at the time that the right of way was granted. The court considered that the presence of the gate would have originally restricted the use of the way to vehicles that could fit through it. However, once that gate was removed by the servient owner, the dominant owner was then entitled to use the right-of-way for larger vehicles. In effect, his rights were expanded by the alteration to the way made by the servient owner. It's worth noting that the destination point of the way seems to generally be less important than some of its other characteristics. In Finch and Great Western Railway, the fact that when granted the way led to a residence and some allotments was held to not mean that it could not be used to access a cattle pen that was later constructed on that same site. There it was emphasised that the use of the way was not restricted solely to the use at the time of the grant. And it's notable that the courts reached that conclusion despite the fact that the wording of the grant expressly referred to a house and allotment in its terms. We should also bear in mind when advising clients that the physical limitations of the way are not absolute, and in some circumstances, even barriers present when the way was granted can be removed. In Keithen and Moore, a right-of-way was granted across a strip of land that was 20 foot wide, but bore a gate that was only around 4 foot 6 inches wide. Like Bulstrode, it was held that once the gateway had been widened by the servient owner to 6 foot 7, the dominant owner was then entitled to use the way for vehicles that could not have previously fit through it. And the court emphasised that where a right-of-way showed that it extended to the whole of an area of land, the topographical circumstances could not properly be regarded as restricting the easement. The dominant owner was entitled to use that whole area marked in the deed. In Charles and Beach, the court went even further and permitted the dominant owner to insist on the removal of the feature that pre-existed the making of the grant. In that case, the servient owner granted the dominant owner the right to use the path or roadway lying between two properties. At the time the grant was made, 2/3 of that path were covered by a flower bed, and it was held that the flower bed was sufficiently temporary an obstacle that its existence could not be said to limit the grant. The dominant owner, therefore, had the right to insist on the abandonment of the flower bed by the servient owner. It was made clear there that the question was one of degree and how transient and insubstantial the obstacle was. We can contrast that approach with the case of Mills and Blackwell, where a stone party wall was not considered to be sufficiently transient, and Vance and Collerton, where a similar conclusion was reached concerning a fence with a hedge behind it. So overall, it seems that it is a rare case where a pre-existing obstacle can be removed to give effect to a right-of-way. To do so will require clear wording as to the extent of the way given in the grant, and a very transient obstacle. So far I've spoken almost exclusively about cases where there's an express right-of-way contained in the grant, but we should also consider the scope of a right-of-way when it's acquired by prescription. First, I should note that once established, it's generally the case that a prescriptive right-of-way can also be used not just by the landowner, but by all lawful visitors to the property, regardless of their identity. But outside of this, where a right is acquired by prescription, there are notable differences in the court's approach than with an express right-of-way. Chief among them is that the court's interpretation of a prescriptive right scope is generally more limited and narrow than with an express right. Obviously, there will be no words to interpret with a prescriptive right, and therefore the extent of the way acquired must be deduced from the actual use made that gave rise to the prescription. This was confirmed in Welford and Graham. It is clear that the extent of the easement acquired by prescription in this case is to be measured by reference to the extent of the use which gave rise to that easement. The direct result of this principle is that the courts tend to interpret prescriptive rights of way more restrictively and are much less likely to find that a wide and far-reaching right has been required. This was illustrated in Wimbledon and Putney Commons Conservators and Dixon as long ago as 1875. You cannot, from evidence of user of a privilege connected with the enjoyment of property in its original state, infer a right to use it into whatsoever form and for whatever purpose that property may be changed. In other words, unlike with an express grant, there will be no starting presumption that the way can be used for any purpose it can be conveniently enjoyed. An illustration of this principle can be found in Forlock and Abicester Limited. There it was held that a user was required to show that he had made vehicular use of the way for the relevant period, or else be restricted to only using it by foot. This was so regardless of the physical extent of the way. Again, this is a excuse me. Again, this is a more restrictive approach than we have seen with expressly granted rights. Similarly, if a way has been used for agricultural or residential purposes, this will not alone be sufficient to justify its use for commercial purposes. An example of that is RPC Holdings Limited at Rogers. There, a right acquired by prescription by using it for agricultural vehicles did not then permit the use of the road for driving cattle, the latter being considered a commercial purpose. It's also important to note that this more restrictive approach also applies to a right-of-way created by implied grant or reservation. It's not just prescriptive rights. When advising, it's also important to note that it is possible for the degree of use of a right-of-way to be considered excessive, even where that use technically falls within its listed scope. The relevant test for this principle was summarised in McAdams Home Limited and Robertson. There it was determined that a dominant landowner's use of an easement could be deemed excessive if A. There had been a radical change in the character of the dominant land or its identity, as opposed to a mere change or intensification of its previous use, and B. The change had led to a substantial increase or alteration in the burden on the servient. This can even be the case where a right is expressed in terms as broad as at all times and for all purposes, because there is still a requirement that the right is not used to the extent that it unreasonably interferes with others with the same right. There are some examples to illustrate that point. In Gilbert and Davies, there the right-of-way was stated as being for all purposes, but it was still considered to be excessive to convert the original site from its agricultural land to a caravan park containing 200 caravans, due to the amount of traffic that would have created on the right-of-way. Conversely, in Stanning and Baldwin, demolishing a single property to build a four-terraced house was not considered excessive, and this was found despite the fact that there was some evidence that damage would be caused to the surface of the track and that there would be an increase in cars accessing the property both during the construction phase and thereafter. I think this illustrates just how significant a change is required in order to be able to make a case for an excessive use. An issue that frequently arises in disputes concerning rights-of-way is repairs. Now, firstly, generally, there will be an implied ancillary right attached to a right-of-way for the dominant owner to enter the servient owner's land to the extent it is necessary to conduct repairs to the way itself. He can even make some improvements to the way, provided that doing so does not prevent the servient owner from using the way how he wishes. However, outside of an express covenant to repair, there is clear authority that there is no obligation on either the dominant or the servient owner to carry out those repairs. Now, outside of that, there is an obligation that can arise where the servient owner does something that disturbs the easement. An example of that is St. and Jenner. There, the servient owner installed ramps on the way, and while that was not an obstruction in itself, it later created an obstruction when those ramps caused the lane's surface to deteriorate. There, it was held that a successor entitled who did not repair the damage would be liable to the dominant owner for adopting a nuisance. But outside of those circumstances, if there is no express covenant, neither party can be forced to conduct the repairs, and nor can they be forced to contribute towards repairs performed by another party. In many cases, this means that a way may simply be left to deteriorate. This was set out somewhat pithily in boundaries and easements. A large number of neglected pothole tracks leading to well-maintained houses is testimony to the fact that the law on this matter is not entirely satisfactory. Further to that issue, it's important to note that problems can still arise even when there is a clear covenant to repair or contribute to repair in respect of a right-of-way. Now, most rights-of-way are part of a freehold, and as property practitioners will know, a positive covenant does not generally run with the land and cannot therefore be enforced against a successor in title. As such, even when there is an express repairing covenant, this can be difficult to enforce once the property has changed hands. There is still some room to manoeuvre, as set out in Halsall and Britzel. There the court relied on a rather ancient principle that a man cannot take the benefit of a deed if it does not fulfil his obligations. The result of that is that a dominant owner who does not fulfill a positive covenant to conduct repairs or contribute towards the cost of repairs can be prevented from using the way until he has done so. However, even that small comfort is of little help if the servient owner is the one who has the obligation, as they're still entitled to make use of their own land how they wish. It will also be of no assistance if there is no express covenant to repair. So in many circumstances, it may very well be the case that there is simply no legal route to require the other party to assist in conducting the repairs. The installation of gates is another issue that often arises in rights-of-way disputes, and unfortunately the authorities on this point are somewhat at odds with each other, so it's perhaps worth going through them in a little more detail. Perhaps the oldest of the relevant ones is Petty and Parsons, where a right was granted from time to time and at all times and for all purposes. And there the servient owner was entitled to erect a gate along the path, whether he was required to keep the gate unlocked at all times and open at all times during business hours, or else it would have been a substantial interference with the dominant owner's right of way. In Guest Estates and Milners Safes Limited, when a gate was erected, it was considered a substantial interference with the dominant owner's right of way, and it was held that it was no answer to that substantial interference to say that the dominant owner would be supplied with the keys. The mere fact of the gate was sufficient. Many decades later, in Johnston and Holdaway, there the court declined to grant an injunction to restrain the servient owner from placing a locked chain across the way. The court considered that as the chain had a combination lock securing it and that the code was provided the dominant owner, it did not amount to a substantial interference with the way. But it's noteworthy that that decision didn't reference either of the previous two cases. Somewhat later in Dawes and Adela estates, a dominant owner sought an injunction restraining the servient owner, who was his landlord, from allowing the outer doors of the block of flats in which he resided to remain locked. The locked door was not a real obstacle to the dominant owner, who had been provided with a key, but it had caused difficulties with the delivery of post. It was held in that case that this did not amount to a substantial interference to the right of way, and that the issue of the postman could be met simply by the landlord giving a suitable undertaking to allow access. Now, that case did reference Petty and Parsons, but it did not mention Guest Estates Unlimited and would seem to almost directly contradict that decision where merely the fact of the gate was sufficient. Now, a much more recent example is Page and Convoy Investments. There, the dominant owner was granted a right-of-way that was stated as being for agricultural purposes at all times, and the servient owner erected an electronic gate to replace an old dilapidated gate that could no longer be closed. The electronic fob and the code were offered to the dominant owner to enable them to have access. But the Court of Appeal upheld the lower court's decision that this still amounted to an unlawful interference, and that the dominant owner was entitled to require that the gate be left open at all times. And it's worth noting again that this is a decision that did not reference Johnston and Holdaway, which again would seem to contradict. And of that same year, there was Kingsgate Development Projects in Jordan. There, the servient owner had placed 3 gates along a short way. The first gate could be opened electronically at the push of a button. The other 2 gates were manual, but were not locked. The court held that the electronic gate was not a substantial interference to the right of way, and neither was the third gate, as that separated farmland from domestic property. However, they did consider that the second gate was a substantial interference, not because of the nature of the gate itself, but because it meant that there were 3 gates over a length of less than 100 metres. So having looked at all that, in short, a servient owner should think very carefully before installing a new gate, or even a new type of gate over an existing right of way, and it would be wise to seek specific advice before proceeding to do so. And if he does seek to do so, the easier he makes it for the dominant owner to access that and pass through that gate without recourse to him, the less likely it will be regarded as being a substantial interference. Finally, I'll address the matter of parking, as this is another issue which frequently arises in rights-of-way disputes. Now, an express right that clearly includes or excludes parking on the way will be fairly straightforward to interpret, but disputes do arise where a right-of-way simply fails to mention parking at all. A right that is expressed as being a right to pass and repass would not normally include a right to park, but it is clear that it can do in certain circumstances. As ever, it's a matter of interpretation based on the individual facts of every case. An example of that uncertainty is in Thurlow Lodge Limited, where the court refused to award summary judgment on a dispute over whether a right to park, load and unload vehicles was included in a right to pass and repass. The court considered that that was a factual dispute that required evidence in a trial before being determined. An example of a right of way which did include a right to park is in McIlraith and Grady. In that case, a right to pass and repass with or without horses, carts, and carriages was held to include a right to stop for the purpose of loading and unloading motor vans. However, in London and Suburban Land and Building Co. and Carey, a right-of-way led to a forecourt on the dominant owner's land suitable for parking. But there it was held that the right did not include a right to unload from the accessway itself due to the presence of that area. Similarly to that, in B&Q plc and Lancashire properties, the right-of-way led to a large unloading area on the Servient land. It was held there that the right did therefore not include a right for vehicles to wait outside on the way, solely because the dominant owner had a policy of only allowing one lorry into the unloading area at a time. In summary then, my advice when parking is in dispute in respect of right-of-way is to pay particular attention to the original use the way was put, and whether parking is reasonably possible anywhere else on the Servient land, particularly anywhere directly connected to the way itself. So thank you for listening to the seminar, and I hope that it was of use to all of you. If you have any questions or anything further you want to talk to me about in connection with the seminar, please feel free to email me at the address shown below. Thank you all very much, and good afternoon.